So what's the process? Once the petition, the physician affidavit, and any other necessary documents are filed with the court, like the letter telling the court that a person who's seeking to be appointed conservator is able to get a bond, and we help with that. The court sets a hearing date and appoints the guardian ad litem, the attorney who represents the respondent, and prepares a notice that the respondent is served. The notice to the respondent contains a copy of the petition, the name and contact information of the court-appointed attorney, and their rights. So it used to be a sheriff. I forgot to update this slide. This is pre-COVID. A sheriff in the county where the respondent lives must personally serve the respondent. Now it is much better. It is a special process server that coordinates with the family, that the attorney makes arrangements for in terms of where's the best place to serve the respondent, what time, etc. But the notice contains the same information, the petition, the interrogatories or medical affidavit, the notice from the court with the date and time of the scheduled hearing, and the contact information for the attorney that represents the respondent, and the list of the respondent's rights. So not only does the respondent get notice, but all immediate family members. So lineal descendants, not step relatives, over the age of 18 must receive notice of the date, time, and place of the hearing because they are allowed to attend. They're not required, but they're allowed to attend. Anyone who is a trustee or appointed under durable powers of attorney or in any other fiduciary role for the respondent must receive notice of the hearing. And all individuals who receive notice are entitled to attend the hearing with or without representation by an attorney. They can just sometimes observe. If someone wants to contest the hearing in any way, either challenge whether the person needs a guardian or conservator, or challenges the person seeking to be appointed, they must hire an attorney. So who is this guardian ad litem person? It is an attorney that is appointed to be the independent eyes and ears of the court who represents the respondent. They must visit the respondent prior to the hearing and explain to them what this process means. If the respondent wants to hire their own attorney, and this usually just happens with older individuals who, for example, have dementia, and may have an estate planning attorney that used to do work with them. And there must be a very special type of hearing called a link hearing that the respondent appears in court and the judge asks them questions to determine if that person has the capacity to hire their own attorney. The law provides for paying reasonable fees to the guardian ad litem. So even though the law requires that the court appoint an attorney for the respondent is responsible for paying for that attorney if they only receive SSI, supplemental security income. They're not required to pay that attorney. The county will pay that attorney. But if they have assets in their name, or if they're receiving Social Security that is not going to a facility in which they're living, the court will assess those fees to the respondent, not to the parents. So there's some stumbling blocks that can occur. If the special process server is not able to serve the respondent, if the respondent won't answer the door and it substitutes sheriff for process server. If they won't answer the door, if the respondent is not present when the special process server arrives, and they will try 3 and 4 times. And now they'll coordinate with the parents. This was really, I apologize, I didn't update this slide. The sheriff used to have so many of these that they had to serve. They would only come back 8 to 5, Monday through Friday. Special process servers will come whenever they're needed. And of course, they are paid. If the address for the respondent is not accurate. So for example, if when the petition was initially filed, the respondent was in a hospital, but is moved after that, and the attorney is not told and does not update the service information, then that may cause a delay. If the respondent refuses to meet with our court-appointed attorney, Even if they will not answer the door and the court-appointed attorney can talk with them through the door, that is sufficient. And again, if there's a dispute over whether the respondent is incapacitated, an independent physician evaluation will be required. If the physician does not agree that a guardian or conservator is needed, if the respondent has moved out of state, and again, if there's disagreement, if there's someone that contests whether the person needs a guardian or conservator or contests who is seeking to be appointed, that can delay this whole process. So what happens if there is disagreement over who should be appointed? And it's usually between family members. Usually the court will postpone the hearing and put it on what's called the contested docket, meaning where there's a challenge. And usually the public administrator will be appointed or some disinterested third party. And very often in these cases, so for example, I have had, unfortunately, parents who are divorced that cannot agree on anything, but their adult child needs a guardian and conservator. It is not uncommon for them to agree, or the court basically telling them either you need to agree on someone that will be hired or we're going to appoint the public administrator. And so that's very often when an attorney or a social worker may be hired by the parents to be appointed. If the respondent does not agree or does not want a guardian and conservator, the court will not reschedule or consider this contested because it's not unusual, unfortunately, for a person over whom this is sought to not want a guardian and conservator. But in that situation, the court-appointed attorney will encourage them to testify. So I talked a little bit ago about the rights of the respondent. So they literally receive this list. They have the right to be represented by an attorney of their choosing, and often it's the court-appointed attorney. They have the right to be present or to decline being present at the hearing. They're not required to be at the hearing. They are entitled to present their own evidence, to cross-examine witnesses, to choose not to testify or to testify, to request that the hearing be open or closed to the public. And really, with the advent of virtual hearings, the court will not allow other people to just watch. Whereas in court, when we had in-person hearings all the time, you would have people sitting in the court, watching and listening to the testimony. The respondent can request an independent medical or psychological examination with the fees paid by the respondent, by the county if the respondent cannot pay, and they can also ask for a jury trial. In 32 years of doing thousands of these hearings, I have not yet had a jury trial in St. Louis County. I have in St. Charles County, but that's extremely rare. So are there more questions?
Yes, we do
Okay.
have a few more questions. People are very engaged, so thank you so much for going through all of this.
Sure.
All right. Someone asked if typically do we see siblings either acting as a secondary co-guardian or conservator, or after the parents pass away or are unable to continue being the guardian? Do siblings typically take over? Is that something we see a lot?
Typically, it depends on the family dynamics. For whatever reason, the court used to appoint a backup guardian, but they don't anymore. So if someone can no longer serve, we file a petition asking for a successor guardian or successor conservator to serve. And it certainly can be siblings. It just depends again on the family dynamics. But very often, if there are good family dynamics and a parent either is just not in a position to serve, usually because of age or disability themselves, a sibling will seek to be appointed.
Next question. What if someone is the conservator, but other family members do not agree with their decisions and believe they're not making decisions in the best interest of the person? Are they either they're too strict or not willing to give the individual some power over their own life, etc.?
The conservator is answerable to the court. And as the attorney for thousands of these, There are very strict parameters. We always have to get court pre-approval for every single expenditure. I mean, every single expenditure, other than Social Security, if there's a representative payee appointed. So we'll talk in a couple of minutes about what's involved in that, but unfortunately, there are often family members that do not understand the process. Now, if they feel that a conservator is being overly restrictive, or if a guardian is requiring someone to live in an environment that is truly overly restrictive, not commensurate with their needs, then other family members can always petition to have that person removed. But the standard for removing a guardian or conservator is very high. You have to show actual malfeasance um, in the eyes of the court. I mean, to prove to the court that there's malfeasance or a
Okay.
significant breach of their duty.
So they would have to gather evidence
Yeah.
and present,
And I've
yeah.
done that before. I've had
Mhm.
guardians and conservators removed.
And then just a follow up to that,
Mhm.
because I think some may be wondering. So if that were to happen, if someone were to petition the court and
Mhm.
someone was removed from being the guardian, would it
Mhm.
then, would the court then appoint, a public administrator? Would that be
That's a good
the?
question. So it depends. It depends
Mhm.
on all the facts, and this is when it becomes very, very fact specific. So
Mhm.
if they're battling family members and the court agrees that the current conservator or guardian is not doing what's appropriate or and has breached their duty, but they feel that the dynamics in the family are not such that they're comfortable because they're very much tunnel vision. They don't care about anything else other than the welfare of the individual before them. And I have to constantly adjust family members' expectations. It's like, I know you feel this way. The court doesn't care. They care about the respondent, period.
Mhm.
Um, so the court may or may not appoint, the family member that was successful in having another family member removed.
Okay, one last one for
Okay?
right now.
Yeah.
Can you ask for another guardian ad litem if you aren't pleased with them and they're being paid by the estate?
Not usually. Not usually. Now, when I am the attorney on a case, as soon as the court sends me, because as soon as we file a petition and the medical affidavit or we, have an emergency, the court will call me and say, okay, these dates are available. I automatically ask, who's the court appointed attorney? Because I've been doing this for so long that I know almost all of them. And I know people that are easy to deal with, that are open-minded, and I know the very few that are very difficult to deal with. But no, you usually cannot. I have literally not had that happen. I'm sure it's happened in the universe of these cases, but I've not had that happen yet. Okay, so let's proceed and I'll take more questions as we go. So the day of the hearing. Most hearings are not contested, so the hearing itself is not adversarial and is very short and is really supportive of what you're trying to do. The court has great empathy and care, and so do the attorneys. I mean, we wouldn't be doing this work if we didn't care about our clients. The physician affidavit, the interrogatories, are presented to the judge as evidence, which allows the physician not to have to come to the hearing. So one of the things that I do as soon as we have those interrogatories, that physician affidavit, I make sure that the court-appointed attorney has them because one of the key questions I have is, will you agree to enter this physician's statement into evidence? And if the court-appointed attorney, which has happened on rare occasions, says no, that means that the respondent doesn't agree that they are disabled or incapacitated. So we either have to call the physician into court and testify, or we have to get an independent medical evaluation. And this is where my judgment and experience of doing many of these will, result in me talking to the court, talking to the other attorney and the family, and figuring out what the best approach is. Um, the day of the hearing, witnesses will testify at the hearing. And so when I'm the attorney, if it is not contested and there are two parents that are seeking to be appointed, I will have one parent, whoever's most comfortable, do most of the testifying on the stand. And then the other, and when I say the stand, if it's in court, then it is on actually the stand. If it is like this, you're just standing or sitting wherever you are and you raise your right hand and the judge swears you in. So one parent will give most of the testimony, and then I will call upon the other parent to say, what's your name? What's your relationship? Do you think you can work with your spouse? And do you agree with their testimony? There may be other witnesses, but not usually. And I almost uniformly never, ever question the respondent. There's no point because I want to give them the opportunity if they choose to testify. I'm not in this to make somebody uncomfortable. It's stressful enough. So it is extremely rare. I can count on less than one hand the times that I've actually asked questions of the respondent. Now, if I have a contested hearing and there are multiple people seeking to be appointed, you betcha I will cross-examine. If the court agrees with the testimony that was given and the physician's statement, the court will usually make a finding of incapacity or disability or partial incapacity and partial disability and enter an order at the hearing. Sometimes, if it's emotionally charged, the court, or even if not, some judges are different. They say, I'm going to take this under advisement and I will get back to you as soon as I can. And the appointed individuals used to meet with the court staff attorney who explains the duties of guardian and conservator, but they really don't do that anymore, unfortunately. So we talked around this a little bit, the least restrictive doctrine. This is the guiding principle in the guardian and conservatorship law, the legal standard that requires that the ward or protectee's liberties should be limited as minimally as necessary to enable them to be as independent as possible while ensuring their safety and meeting their needs. And this applies to everything, their living setting, their social interactive issues and handling of their finances. So the elephant in the room, what are the costs? The petitioner or someone else bears the cost of hiring an attorney, when I'm in that position, the filing of the petition and representing the petitioner. If the guardianship matter is contested, costs will increase. The costs are charged to the estate of the person, the respondent, unless, again, the protectee only receives SSI and has no income or only a house. Someone who's truly indigent. So I do a number of cases through the Veterans Administration and other nonprofit organizations where I don't charge fees, and we can then ask the court to waive the court costs. That's by filing a special petition, which is called an informa pauperis, that asks the court to waive filing fees and costs. If someone files seeking to have a guardian and conservator appointed, I just had this happen this past fall, and the person does not proceed with the case, the court will assess the attorney's fees for the respondent against the petitioner. Because that is not usually what happens. Again, it's either the court-appointed attorney's fees are paid by the respondent if they have more than SSI, or the county pays those fees. But if the petitioner files a case and it doesn't proceed either because there's not enough evidence, or the person just decides, look, I'm not going to do this anymore, they will be responsible for the court-appointed attorney's fees.